to talk about the latest in the massive election meddling case against the former President Donald Trump and his co-defendants. So the latest thing here is that one of his co-defendants is accused of threatening a witness, Trevion Cuddy, who was a publicist. But Josh, I know that you've been following this very closely as well. Apologize, I'm trying to fiddle with this new computer and calling up the wrong video for the wrong story. But I know you've been following this very closely. What's your take, Josh?
I tell you, this case fascinates me not just as a professional who's into law, but this is our political livelihood. This is what makes us citizens. It's what makes our world run, is how our institutions function. And I was down in the Fulton County Superior Court for some of the very spirited arguments on Friday in front of Judge McAfee. Most of Friday was involved in pretrial scheduling and some other motions practice, with the big takeaway being that the president has come out and told Judge McAfee, hey, the calendar suggested by D.A. Willis and the special appointed district attorney Nathan Wade, that calendar is not appropriate and it's not going to function well considering the other matters that former President Trump has to deal with. He has at least 3 other substantial trials basically happening at the same time. That then brought into the idea of how would former President Trump be able to campaign during an actual trial, where his presence is absolutely allowed. In fact, most of the time it's encouraged. How would he be able to run for president while on trial? And then, believe it or not, would the president be able to be tried if this trial calendar is pushed into 2025, where therefore the president or the former president might be reelected? There's a big discussion as to whether you can put a serving president on trial. Many people believing the public policy is no. Most states have a history of not allowing the trial of actively serving executive level elected officials because of the ability to weaponize the criminal process. We will have to see, because this is an issue of first impression for our federal courts. Never before have we had a president being on trial, being subject to the call of a calendar and the discretion and jurisdiction of state Superior Court judges during an active campaign, let alone after an election where they may be reinstalled into power.
Absolutely, absolutely. And so you were saying that you anticipate also a motions hearing, a bond revocation hearing specifically regarding this defendant who is accused of threatening a witness.
Yes, thank you so much for reminding me. And the Cuddy case, Cuddy is the former PR, employee of Kanye West, and was involved in the Trump issue primarily as it relates to how or whether the Trump universe decided to facilitate with Ruby Freeman and her daughter, the 2 older skewing African-American election workers here in Fulton County. We remember the great suitcase video and Rudy Giuliani and all that discussion over whether the countdown at the Phillips Arena was corrupt in some manner. Ms. Freeman is covered by all of these bond conditions as one of the people that no one is allowed to contact, let alone harass or threaten. Over the weekend, it became known, and this exploded this morning, that Ms. Cuddy, while on video on some sort of social media spaces or other recording, made pretty clearly unmitigated threats to Miss Freeman about what was going to happen to her after this was all over. And now there is a wide-ranging call for Judge McAfee to revoke her bond. I expect a filing will be forthcoming very quickly. Spoken with a number of other people involved in the situation, and we all believe that this is such a clear-cut violation that Judge McAfee can't afford to hold back and try to split the baby like he did with the prior revocation discussion and hearing. We're going to see a much stronger action, I believe, from Judge McAfee when this comes before his court.